Well, hello again. Thanks for returning and watching this video and this playlist. If you're just starting here, I would recommend that you go back to the beginning and watch all the way through. This is just a little section for a brief discussion of the word income, because most people fail to understand what income is and what it isn't. But to get a complete understanding, to get to this point, you may want to watch the other videos in this series. So I've heard many people say, income is theft. Income is illegal. Income is, property. Those are incorrect on all counts. Income is not property. Income can be derived from property, but income is not property. There is no property right in income. Income is merely a excise tax, which is a tribute levied by a superior party to an inferior party for a privilege of doing something. So income is derived from the stream of commerce, which is not under the natural law of God. It is within man's civil law, and in the United States, it's under the maritime law and the Uniform Commercial Code, the UCC. And that's because, again, it's something. Here is the first quote we'll use. It's from Doyle versus Mitchell Brothers, 247 U.S. 179, 1918. And we have a constitutional amendment in America, in the U.S. Constitution, that made income tax constitutional. And there was income taxes before then, but now they just put it in the Constitution, and then there are several income tax acts after the 16th Amendment. But there was income taxes in several states before the 16th Amendment, and there was nothing unconstitutional or unlawful about those, because income is an excise on a privilege. What's the privilege? The privilege is being an employee occupied in an occupation for some sort of licensed commercial business entity in the stream of commerce. So what income is the employee's share of the corporate profit and gain derived from the stream of commerce. You get that? Income is a tribute paid to your master for a privilege of equitably converting your labor to become an employee in the stream of commerce, working for a commercial business entity, i.e. a corporation, LLC, trust, sole proprietor, LLP, whatever that commercial business entity is that's licensed and registered with the state and or United States with an EIN or TIN, some other taxpayer identification number. And you're employed in an occupation, possibly even with an occupational license or a professional license on top of your social security number, and you're being paid in fifth plank central bank funny money, monetized debt. Are you starting to see this picture? So the act employs the term income in its natural and obvious sense as importing something distinct from principal or capital. Income is not capital or principal or property. And conveying the idea of gain, profit and gain from corporate profit and gain, or increase arising from corporate activities. Okay? This is called corporate capacity. In order to earn income, you have to engage in corporate capacity. Okay? And all corporations are heavily regulated and controlled. Anything engaged in corporate capacity is heavily regulated and controlled because it's not part of this law. The law of nature and nature's God, it's not part of the law of God. It is strictly within the jurisdiction of man's civil law, and more specifically, man's forms of commercial law. And then here in the United States, that's the UCC and the admiralty maritime. Okay, income is very simple, but you think you own your labor. No. You made an equitable conversion. When you cross the boundary line, let's say this edge of this little document here is the boundary line. Over here is the natural common law, the law of God, where you have property and property rights and increase of wealth rather than income. And over here is the stream of commerce. To cross that boundary line, that jurisdictional boundary line, you created an equitable conversion by your own consent to pledge your labor over here into a pool of assets used by your employer in order to generate the income that you're seeking. This is a wager. You're betting, hey, I can make more, I can have more debt, credit, because you're not paying debts over here. But you think you can live a richer lifestyle over here in this form of law, earning income from corporate profit and gain than you can over here in the natural law of God, earning wealth production, which is property. And I hate to break it to you, but here in the United States, this is going to come to a shock to everybody. Property, when you own it, really own it, go watch the videos, the second and third video in this series. Do you really own that? Because you don't own anything in Elodial anymore. But if you own property in Elodial, property has never been taxed or assessed in the United States. People are going, what? I pay a property tax. Yeah, you call it a property tax, but it's an ad valorem tax on the value of the property because you don't own it. It's a rent, serf. You're paying a tribute to keep your legal title to possess and use the state and central bank and the United States' house. If you think you own that house, stop paying those tributes. We'll see how long you own it. The real master is going to come because you stop paying your tribute, the real owner, because you just have a mere legal title to possession and use. Now, for those of you that haven't watched that video, let me pull up. Where is it? We got so many things open up here. Here we go. I've shown this several times in these videos, but here, let's review it again. 73rd Congress, first session, Senate document number 43, April of 1933. This is after March 9th in 1933 when U.S. Inc. and all its corporate members, 14th Amendment U.S. persons, declared bankruptcy. And you haven't paid a debt at law since. You've only discharged debts in the UCC and maritime and equity with commercial paper. The ultimate ownership of all property, that includes labor, kids, if you're under parens patriae, watch the first video in this series, is in the state. Individual so-called ownership is only by virtue of government, i.e. law, civil law, UCC, maritime law, equity, amounting to mere user. And use must be in accordance with law and subordinate to the necessities of the state. This is the first plank of the Communist Manifesto. And there's a video in this series too. Are you a commie? You probably don't even know it, but you're a full-on commie. Because you're keeping the 10 planks of the Communist Manifesto, not the 10 commandments. Legal title is one cognizable or enforceable in a court of law, or one which is complete and perfect so far as regards the right of apparent right of ownership and possession, user. Yeah, you have an equitable interest in the property to possess and use it, but your use must be in accordance with the civil law of the master who really owns it. But carries no beneficial into the property, the state has that. Another person, the state, being equitably entitled thereto. In either case, the antithesis, the opposite of equitable title. It may also mean appearance of title as distinguished from complete title, which is what Elodial is. Full and absolute title or apparent right of ownership with beneficial or equitable title in another, not necessarily record title, a tax title, which is prima facie valid as a legal title. Okay, let's look at Elodial. This is what we used to be in America, but you're not anymore since 1933. Elodial, not free, not holden of any lord or superior, i.e. the state or fifth plank central bank, the Federal Reserve. Owned without obligation of vassalage or fealty, which would be your excise taxes, your tributes, income, property, sales, all that. Registration fees. You know, you got to register your car. You got to register your guns. Licenses to use, because it's not yours. If you try to use somebody else's property, that's stealing. The state and the bank own this property. You need a license to use it, kid. The opposite of feudal, the Elodial is the opposite of feudal. Well, that's where you're at now. You're back in a feudal, neo-feudal serfdom. Elodial, land held absolutely in one's own right and not of any lord or superior, the state, the banks, etc. Land not subject to feudal duties, taxes, easements, assessments, or burdens, permits, licenses, building codes, use statutes. An estate held by absolute ownership without recognizing any superior to whom any duty is due on account thereof. And that's because you're not homo liber, a free man, an Elodial proprietor, as distinguished from a vassal or feudatory. You're back to being neo-feudal serfs by your consent. Parens patriae, go back to the earlier videos. You'll start to see this. So because of this, do you own your labor, or have you pledged it into a cauldron, into a communal pot of the corporation called the United States, when you got your social security number, which is your taxpayer ID number? That's that equitable conversion. You cross the jurisdictional boundary line. You're behaving as though you're over here in the common natural law of God, and you're over here in this commercial law. And you're complaining and bitching and moaning about it and saying, well, income is theft. Taxes are theft. No, they're not. They're tribute you owe to your superior for contracting into this mess. Now, you can get out of it if you want, but that's called repentance, and most people really don't want to do that. Repentance is difficult. Let's go along here and we'll find a few more here. Let's, in a few of the previous videos, I kind of pointed out this individual thing. Individual versus the person. Okay, Hale versus Hinkle, 201 U.S. 43, 1906. We are of the opinion that there is a clear distinction in this particular between an individual and a corporation, or something engaged in corporate capacity. And that the latter has no right to refuse to submit its books and papers for an examination at the suit of the state. You know, when you're engaged in corporate capacity, kids, as an employee in the stream of commerce, you can't refuse to submit your books and papers to the IRS. Not regarding your employment or your commercial business activities, you certainly can't, because you're engaged in corporate capacity. Now, you've got some rights there. You got some civil rights and some privileges and immunities that you can exercise, but you know, you're knee deep. Actually, you're up to your neck. The individual may stand upon his constitutional rights, which includes pre-existing rights that existed in the law of nature before even the Constitution was written, as a citizen. Now, I had several videos here about this citizen thing. This is the inhabitant, not the corporate member. He is entitled, remember, we still, before 1933, there were still some of those people running around. After, even though, a lot more of them. He's entitled to carry on his private business. See, everything you're doing in the stream of commerce is public. Your business is probably open to the public. It's probably affecting the public. It's seeking customers from the public. It's not private, and we'll go over that. There's a Supreme Court case kind of doing that too. So private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation, so far as it may tend to incriminate him. He owes no such duty to the state since he receives nothing therefrom. Ouch. Did you get public school education? Do you have various state and federal issued licenses? Have you received any bailouts, like recently, but probably going back in time too? Have you ever collected unemployment or some sort of, did you ever apply for any grants or loans from the government? Have you have you ever participated in Obamacare or received Medicare or Medicaid or disability or anything like that? All your licenses, everything, you receive a lot therefrom. That's your problem, beyond the protection of his life and property. Upon the other hand, the corporation is a creature of the state. The person, remember, I've shown you, persons are creatures of the state, creations of the state. You're operating as a person on the commercial civil law stage. You don't own that labor anymore. You pledged it. You made an equitable conversion. Let me show you this real quick before this is easier to find this one in a book here in one place. By definition, a legal title is the opposite or at least the antithesis of an equitable title. Now I showed you that on the screen. It is the beneficial interest of one person whom equity regards as the real owner. Okay, so that's that equitable title, although the legal title isn't vested in another. So you get to possess and use it, all that. This dividing of true title, Elodial, into a legal title on the one hand versus the equitable title on the other is called equitable conversion. What's a conversion? It's an alteration, an interchange, a metamorphosis, a passage, a reconstruction. While reconversion, as a noun, is a change or changeover, a rebirth. Jesus answered and said unto them, Verily, verily, I say unto thee, except a man be born again, he cannot see the kingdom of God. John 3:3. The word legal originates in the idea of being connected to a legal system by contract. The connection is created by consent. What is to be legal becomes law by that consent. Now, I think I've said this before. In the United States, if you take any action or file into a court for a judge to adjudicate, he's going to put up this dividing line, and he's going to look at that paperwork and decide, is this a question of property and property rights or a mere matter of regulation by contract, typically in commerce? But it doesn't have to be commerce. Is it a mere matter of regulation due to contract? Or is it a property right? So when you bring in a tax case, are we dealing with property and property rights, or are we dealing with a mere matter of regulation via contract, and in this case, in commerce or the UCC and the maritime commercial law, the civil law of the state? It's not theft, kids. It's not illegal. Okay, so this is a quote from Diefendorf versus Galay, which was an Idaho Supreme Court case. Like I've said before, you're going to get some truth from judges. You'll never get truth from a politician. They just lie all the time. But sometimes judges tell you the straight skinny. And I think Diefendorf Galay is one of those cases. And this, even though this is Idaho, income works the same way everywhere around the world. Income is necessarily the product of the joint efforts of the state and the recipient of the income. Right? The recipient of the income was created by the state. These commercial business entities, all these persons out here with social security numbers and EINs and TI, those are all creatures of the state, engaged in corporate capacity. The state furnishing the protection necessary to enable the recipient to produce, receive, and enjoy it. And a tax thereon, in the last analysis, is simply a portion cut from the income and appropriated by the state as its share thereof. The state provides you a commercial economy, a stream of commerce for which you can cross that jurisdictional boundary line from the natural law of God, where you've got private business under the laws of God in his economy, and you say, well, this is a whole lot of hard work, strict liability and all that. I can come over here and convert my labor into employment and earn income, and I can go out and buy all kinds of stuff that I wouldn't necessarily be able to buy over here if I got to work over here without using the stream of income or stream of commerce. So the state's just taking off its share, dude. You're bitching about your superior daddy who's providing all this good stuff for you, and you're bitching about having to pay him for his share of what he's done for you. Wow. Ungrateful, little selfish. Gee, and you wonder, you think you're going to treat the God of creation any better? I don't know. All right, here's some more from Diefendorf and Galay. Excises, tribute. That's what income. All taxes in the United States fall under this category. They're all excise taxes. They're all tribute owed for engaging in a certain activity or doing a certain thing, or all that. There is no direct taxes in the United States on your head or on your property. That's very rare. It's all excises. And 99% of them are over here in this commercial law. In their original sense, were something cut off from the price paid on the sale of goods as a contribution to support the government. The word has, however, come to have a broader meaning and includes every form of taxation which is not a burden laid directly upon persons or property. In other words, excise includes every form of charge imposed by public authority for the purpose of raising revenue upon the performance of an act, the enjoyment of a privilege, or the engaging in an occupation. These are all regulated and controlled commercial business and civil law business activities. Occupation is something done in the stream of commerce, corporate capacity, as a numbered registered, or with a numbered registered Social Security number, taxpayer ID, EIN, employer identification number, TIN, taxpayer identification number. Federal employee or employer discharged with Federal Reserve credit in the hopes of obtaining corporate profit and gain, income. It's not illegal. It's not unlawful, it's not unconstitutional, and it's not theft. Where did I highlight Schaefer versus Carter? Oh. Okay, now let's see. I think there's some up here. This is from U.S. Supreme Court Schaefer versus Carter in 1920. Governmental jurisdiction in matters of taxation depends upon the power to enforce the mandate of the state by action taken within its border, either in personam or in rem, due to the subject. In rem is the subject matter. Well, taxation is fully within the subject matter jurisdiction of the commercial law. Net income derived from interstate commerce is taxable under state law, providing for a general income tax. The Constitution, including the 14th Amendment, does not forbid double taxation by the states. If any of the taxes thereon levied become delinquent, they shall become a lien on the property, personal and real, of the delinquent person, and shall be subject to the same penalties and provisions and they are all ad valorem taxes. All, that property tax you pay on your house is again a tribute because you don't really own it. But it's an ad valorem tax. If we're going to define it by a tax, it's an ad valorem tax. It's a tax on the value of the property denominated in U.S. Federal Reserve dollar units. So as that value fluctuates up and down, so does the ad valorem tax. Okay. Okay, now what about deductions? Deductions from a tax are a matter of legislative grace. This God shows grace and mercy too. And if the grace, but it's a little stiffer, grace is not sufficient to leave something over for the taxpayer, he has no legal grounds for complaint, whatever the hardship may be. The mere fact of intake being less than outgo does not relieve the taxpayer of an otherwise lawfully imposed tax. Wow. Boy, that God shows you a lot of grace, doesn't he? Oh boy, oh boy, oh boy, oh boy. Yeah, that's Pharaoh for you. Pharaoh increased, it started off when those Israelites consented to be Pharaoh's resident aliens and bound themselves to pay Pharaoh a 1/5 or 20% income tax by their consent. Did it stay 20%? Did it stay 1/5? Or did it, over the years, increase? You got to be careful of that income stuff, man. That is... Oops, wrong one. Just did that one. Remember, admiralty. The development of admiralty in the United States. The admiralty jurisprudence system was brought to America by British settlers along with the common law and equity. And remember, that common law goes back to Mount Sinai. Now, it's been corrupted. You got to be careful of that. Equity is like Solomon and the baby. When there's no remedy in the law or in civil law, then equity follows the law to give remedy where there is none in the law. Like with Solomon and the baby, there is no law in the Torah that tells people, hey, when a baby's born, if there's two mothers, that's absolute absurdity, right? When a baby is, if we don't know who the mother is, here's how you solve that. See, there's nothing in the Torah about that. So it devolves onto equity to provide a remedy based on what's just right and fair, and the judge has to make this equitable decision. So Solomon used a little bit of cunning here to determine not necessarily who the mother is, but which of these women had the best interest of the child at heart. And he figured that out, and therefore he awarded custody to that child by the mother who was going to love and care for that child, or the woman, not necessarily the child's mother. We don't know that. It doesn't say. The courts for the administration of maritime law were commissioned in many, if not all, of the colonies. These tribunals to exercise the power conferred upon them until the organization of the federal government in 1787. Now, before the adoption of the Constitution, jurisdiction in admiralty maritime cases was distributed between the Confederation of the individual states. But when the Constitution of the United States was framed, a system of exclusive federal admiralty jurisdiction was incorporated, placing the entire subject, substantive as well as procedural, under national control because of its intimate relation to navigation and to interstate and foreign commerce. What has subject matter jurisdiction over commerce? The maritime law. Now, this provision of the Constitution did not abrogate the maritime law, theretofore enforced. The maritime law became the law of the United States, subject to the paramount power of Congress. The Constitution gives plenary and exclusive and absolute power over Congress. to alter, qualify, and supplant it as experience and changing conditions might require. Oh boy. Subject only to constitutional and treaty limitations. The power of Congress is paramount in matters of maritime law. Let me scroll up here. This jurisdiction of admiralty has since been modified and enlarged by numerous acts of Congress, enactments. Social Security being one of them, kids. Social Security being one of them. Now, this will trip your trigger. I'm just going to throw this in there. It's a little off topic, but this will be interesting for you. A good place to find U.S. law, there's lots of them, but one of the ones I use is law.cornell.edu, Legal Information Institute. You can come down here, legal resources, and your primary sources. You can click the Constitution, U.S. Code. We're going to click the U.S. Code here. And I'm going to show you in this book, but I'm going to show you how to find this stuff. So title, put in the title. I'm going to put in Title 42. And I'm going to put in section 666. That might wake you up. Requirement of statutory prescribed procedures to improve effectiveness of child support enforcement. If you watch that Parents Patre video, you'll start to understand this. Now let's go down. We're going to scroll down here to paragraph 13. See if we can find it here. Oh, there's 8. Oh, 14. A little faster. Oh, yeah, there. Okay. 13. Recording of social security numbers in certain family matters. Procedures requiring that the social security number, A, an applicant for a professional license, driver's license, occupational license, recreational license, or marriage license, be recorded on the application. Now that's the important one there, okay? And the reason I showed you this is your social security number is your taxpayer ID number, it's your employee ID number, and anytime you're going to apply for any kind of license from the state over and above this license to be employed in commerce, right? You got to provide that social security number. I thought it was very interesting that they put that under the under the section 666. You know, that Mark of the Beast has been here for a long time. It's just not consolidated yet into one thing. That's coming. All the elements of the mark are in your wallet. They're just not consolidated and they're not mandatory yet. They're all still voluntary, but that's going to change. License. License is the permission by competent authority, not necessarily government, but often is for persons under Parents Patre, to do an act which without permission would be illegal or trespass or a tort. A license is permission. Can you just go engage in the stream of commerce, which is regulated and controlled by the king? Of course not. You need a license. You need the king's permission. Let me see what else I've missed here before I open up some other stuff here. Oh, Wickard. Yeah, Wickard. This is a great case from 1942 of the United States Supreme Court. This is basically dealing with subsidies, a benefit from the government that you've applied for, you prayed for. You went out and asked, begged, and the superior God for. Okay, what this is this is during the Depression is when this all took place. The case was decided in 42, but the events that made up the case were back in the 30s. And this is due to a farm price support program, a farm subsidy program for wheat. Okay, basically the background is the farmer signed up for the program, which limited the amount of wheat, the number of acres that you could grow wheat on. Now the farmer got this clever little sneaky idea because of his greed, sloth, and all that stuff. You know what? I'm going to grow, 10 or 20 more acres. I've got the extra land. I'm going to grow more wheat, but I'm not going to sell it to the government through the stream of commerce. I'm going to keep it for myself and use it to feed my livestock and blah, 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 blah. Okay. The government found out about this and sued him. And then he, wait, I got a property right. No, dude, you signed a contract and you did an equitable conversion. Okay, so let's see what the highlights are here. It is well established by decisions of this court, the power to regulate in commerce includes the power to regulate the prices at which commodities in that commerce are dealt in and practices affecting such prices. Now, see, here's what everybody misses about this. If that farmer hadn't signed that contract with the government, he could have grown as much wheat as he wanted to. The government had no business telling him how to grow how much wheat as long as he had the legal title to that land. But he would have had to take in all that wheat into the open market, not the price supported market, and sell it at what he could get in the open market, which would have been substantially less. Probably half, if not a quarter, only a quarter of the price that the government was willing to pay if you participated in the program. This is how government entices you. They dangle that shiny thing in front of you and they appeal to your vanity, jealousy, lust, greed, fear, envy, and sloth and get you to operate as a human, a subman, a man wallowing in the mire, human, rather than righteously rising up to the level that God created you for. Okay? And that's what this farmer did. But then he wanted his cake and he wanted to eat it too, so he grew more wheat because he's greedy. It is the essence of regulation that it lays a restraining hand on the self-interest of the regulated, and that advantages from the regulation commonly fall to others. The government gave the farmer a choice, which was, of course, designed to encourage cooperation. Oh, hey, we're dangling this carrot in front of you. We just want you to cooperate with us and discourage non-cooperation. They don't like dissenters. They want everybody on their government tit. That way they can regulate and control everybody. All right? We can hardly find denial of due process in these circumstances. What's due process? Yeah, he's claiming this to be a property right. Oh no, dude. This is a mere matter of regulation and commerce. We can hardly find a denial of due process in these circumstances, particularly since it's even doubtful that the appellee's burdens under the program, under the contract, outweigh his benefits. It's hardly lack of due process for the government to regulate that which it subsidizes. The government subsidizes the commercial economy of the United States all the time. It wouldn't exist without the government's heavy hand. That's what commerce is. It is the king's prerogative. It's public business. Over here in this law, you got to do everything privately. You can't affect the public. You can't affect the public in any way in this form of the economy that's in this book, in that form of law. I forgot to open one here. I just thought about it. Oops, I'm going the wrong way. Let's see here, Chaz Wolf. Where are you, Chaz? Oh, I thought it was over here, Chaz Wolf. Where are you? You're hiding and I'm just not seeing you. Oh, that's why. I'm not in the case sites. Duh. Okay, let's see here. Chaz Wolf, there we go. Now, what's the difference between a public and private business here? This goes back to 1923. Again, the Supreme Court, 262 U.S. 522, and Chaz Wolf Packing Company versus the Court of Industrial Relations of the state. Okay, first, The act declares that the preparation of human food is affected by pay attention here as we read through this, how many times the Supreme Court uses the word public, affected by a public interest, and the power of the legislature so to declare and then to regulate the business is established in. Second, the power to regulate a business affected with a public interest extends to the fixing of wages in terms of employment and secure continuity of operation. Business is said to be clothed with a public interest, justifying some public regulation, may be divided into three classes. One, those which carried on under the authority of a grant of public grant of privileges, which either expressly or impliedly imposes the affirmative duty of rendering a public service demanded by any member of the public. Such are the railroads and other common carriers and public utilities, to name a few. Okay. Two, certain occupations regarded as exceptional, the public interest attaching to which, recognized from earliest times, going all the way back to Cain's Enoch and Nimrod's Babylon, has survived the period of arbitrary laws by parliament or colonial legislatures for regulating all trades and callings. Such are those of the keepers of inns, cabs, grist mills, where you took your flour and grain to be ground up. Okay, these are all affecting the public. These were called public houses rather than a private house. You can come and stay at my house, and that's a private house, but I have to invite you in. If you break into my house to stay here without my permission, without my license, well, that's a violation of my property rights. But if I invite you in to stay, that's a private house. I am not open to the public. But keepers of inns were public houses, and they were, declaring themselves, advertising themselves, putting up signage. Hey, Howard Johnson's Holiday Inn, open to the public. Here's my public hours. Okay, that drags you from over here in this private business over here into this public business. Okay, now let's look at this third one, because this covers everybody else that doesn't stay within over here into this jurisdiction. Businesses which, though not public at their inception, hey, I'm Joe Blow, I'm going to start a business. Well, okay, did you go and get a business license? Did you go get a tax collection permit, a sales tax permit? Okay, you're starting your journey into the public. May be fairly said to have risen to be such and have become subject in consequence of some governmental regulation. They have come to hold such a peculiar relation to the public that this is superimposed upon them. In the language of the cases, the owner, by devoting his business to the public use. Are you open to the public? Are you advertising in the public? Are you affecting the public? In effect, grants the public an interest in that use and subjects himself to public regulation to the extent of that interest, although the property continues to belong to its private owner and to be entitled to protection accordingly. Again, he still has that legal title to possess and use this property, but use has to be in accordance with the rules of the state. And when he publishes that he's open to the public, he's doing things in the stream of commerce. So here's my editorial comments. If you've got a state-issued birth certificate, a social security number, you're a 14th Amendment U.S. citizen, a U.S. national, a U.S. person, and or your business has an EIN or TIN, also U.S. person, sole proprietor, LLC, LLP, S Corp, C Corp, etc., and is registered with the state, it's as a registered sales tax collector or tax collector, sales tax, Social Security, FICA, FUTA, etc. It and or you file tax returns and your business is open to the public, affecting a public interest, accepting Federal Reserve notes, credit, bank checks, blah, 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 commercial paper, then it's not truly your business. You've opened it up to this public interest. And the king, the state, the government, your papa has the power to regulate and control you now. It's the government's and the Fed's business with that equitable title. You have the mere legal title, and you've now, instead of, see, even if you're all this stuff, you can still do stuff privately. Now, if you accept Federal Reserve notes, well, there's a filing requirement, a certain filing requirement on the acceptance of those Federal Reserve notes. You got to be careful with that. There's no commercial paper allowed in this law, kids. No notes, no bills, no checks, no credit, no stocks. None of that commercial paper within the UCC. That is unlawful. That's a sin. Substance out of the earth that God created is what he uses as consideration and reciprocity in all private transactions. Okay? So are you starting to see this income tax problem that you got? It's not a problem. It's a tribute to your master. Okay? You have a tribute to your master because you're engaged in commerce and you equitably converted your labor. Remember, where is it? The act employs the term income in its natural and obvious sense as importing something distinct from principal or capital, property, and conveying the idea of gain or increase arising from corporate activities in the stream of commerce, public business. So you owe a tribute to your master. It's not theft. It's not a usurpation of power. You did this to yourself out of your own ignorance. You equitably converted your labor. The Bible talks several times about a cauldron, especially in the King James. I don't know what other versions use, but there's the word cauldron used. And in that cauldron, people backbite. Okay? When you join the cauldron, you got to pay. So I hope this has helped you people out with this idea of income being theft or illegal. It's not. It's a tribute to your God that you have bound yourself to in a foreign and alien jurisdiction called human civil law. Thanks for watching. Remember, this is not to be construed as legal advice. It's for educational purposes only. Bye-bye.